Joshua Zoman and Jackie Fulford for Mrs. Adelson.
Good afternoon, Your Honor. John Rollo on behalf of the witness, Wendy Adelson, and my colleague, Matthew Luca, is with me as well.
Good afternoon. I have reviewed your motion, Mr. Loro, concerning the defense's subpoena as far as placing a statement on the record. I don't know if any of the parties have a position concerning you placing a statement on the record, but similar to the other trials in this matter, I do not have an issue if you do so prior to the testimony of your client.
Now, this emergency hearing here supposedly is because the defense wants to subpoena Wendy as well. Now, there's already a state subpoena where Wendy Adelson can testify under immunity, meaning it's a limited immunity that what she says in her testimony cannot be used against her in a later trial, if it becomes a trial against Wendy as well. Now, the defense filed a motion. They also want to subpoena her. And it appears as if Wendy then said, if my mother is going to subpoena me, I'm going to plead the fifth. Now, what does that tell us? Well, now, of course, trial rules, we should not draw any inferences to Wendy pleading the fifth if she has to testify under a defense subpoena. But we can. And it seems like Wendy has Donna has information Wendy does not want to be out there. So this will be really, really interesting.
As to the placing the statement on the record, does the state have a position?
No objection, Your Honor.
Does the defense have a position?
No position, Your Honor.
Concerning placing a statement on the record, Mr. Loro, you will be permitted to do so, or another member of your firm, before your client testifies. As to the motion to quash the defense subpoena, does the state have a position?
No, Your Honor. No position.
Does the defense have a position?
Yes, Judge.
Go ahead.
May I stay here?
You may.
Judge, the issue here and the concern that we have on behalf of Mrs. Adelson is there have been two prior rulings in the homicide of Mr. Markel. One came from Judge Hankinson, and then another one came from Judge Wheeler. What Judge Hankinson ruled is that the immunity conferred by the state subpoena extended to cross-examination, and we believe that's an accurate statement of the law. However, Judge Wheeler limited cross-examination to only what the state brings forth on direct. This is a premature at this point, Judge. We have her under subpoena, and we may want to elicit testimony from her.
Well, before we get there on that point, when she's called as a state witness and she is cross-examined, she can be cross-examined on all matters raised by the direct and on matters of bias or impeachment or motive to lie. All matters that she can be cross-examined on pursuant to the rules of evidence extend under that state subpoena.
Yeah, so it seems that the second judge, his ruling was a bit too much of a limit for the defense. They want to question Wendy about more. And it seems like the judge is acknowledging this. At least that is my interpretation.
I understand that, Judge, but our issue is, suppose that she's one of the first witnesses to testify, and suppose after she testifies, other issues come up that we know, if we called her, she could rebut what has been said. It's not necessarily, it would be something that she would need to invoke her rights. It could be a very simple issue, and we would need her testimony. So until we go through the trial to see what happens, it's impossible for us to say, yes, just cross-examining her on bias and credibility and whatever the state has asked about sounds good in the state's case until we hear further testimony and some issue arises.
I'll allow Mr. Lawyer to make his argument, but the crux of his motion is you cannot offer this witness any protection, as it relates to you calling her in your case in chief.
Which is absolutely correct. The defense cannot offer Wendy immunity. For me, that if I were the defense attorney here, Your Honor, we are defending our client. We don't give two shits on a straw about Wendy Adelson. Her mother might. We don't.
What is your response to the written argument on that matter?
Yes, Your Honor.
Hold on, Mr. Law. I'm going to allow Ms. Fulford.
I'm sorry, I thought you were asking me. I'm sorry, sir.
You can make your argument in just a moment.
Yeah, so the issue as to immunity, we cannot confer immunity to her, Judge. We agree with that. We can't. But there may be other issues where she could testify to something that she's not taking a chance, if you will, that she's going to say something that could be used against her in the future. There could be other matters that are raised in the trial that we simply want to get testimony from her as. She is the daughter of our client.
From the perspective of your client, I certainly understand the argument you're making. Mr. Lauro, you may argue.
Yes, Your Honor. This issue was addressed by Judge Wheeler in the second McBanawa trial. It was also decided upon by the first DCA in July 2025, when the DCA ruled that the procedure used by Judge Wheeler was entirely correct, and the subpoena in that case was quashed. It was the same issue that the defense raised, where they wanted to cross-examine my client pursuant to a defense subpoena, which conferred no immunity at all.
Yeah, the person talking now is not the prosecution. This is Wendy Adelson's attorney. Just to be clear here.
On Ms. Adelson, I indicated to the court then, as I will now, that Ms. Adelson will assert her Fifth Amendment rights with respect to any relevant question asked by the defense. So the only result of the defense procedure would be to have the client's daughter take the stand and invoke the Fifth Amendment in front of the jury. And that the court decided by Judge Wheeler that would be inappropriate. And we would ask the court now to follow the same procedure as Judge Wheeler and follow the same procedure that was upheld by the first DCA just 1 month ago.
Does the defense have any remaining argument on this matter?
Your Honor, respectfully, the issue that was ruled on or concerning the subpoena and quashing the subpoena, Ms. McBanawa did not make that argument below. She did not join the state's motion. So the first DCA did not rule that Judge Wheeler followed the proper procedure. My understanding is that the first DCA held that she had not preserved the argument.
And if I could add one thing further,
We don't have tag team motions. Who's going to finish the argument?
Just a moment, Your Honor.
Yeah, no tag teaming argument. So, hey, tell me the argument. Tell me the argument so I can say it. Yeah,
Your Honor, factually, we're in a vastly different circumstance. Our client certainly has information, knows information about her daughter that Ms. McBanawa would not have ever been able to know. And so it's our position.
Yeah, that is definitely true, because mother-daughter knows definitely more than Catherine McMurray, who is currently serving life in prison, if you didn't know. I covered parts of that trial a couple of years ago. So yeah, it is different. It really is.
That it's premature. The Fifth Amendment question, the courts have ruled, should be done on a question-by-question basis.
So your expectation is for me to ask the question. She will make some sort of signal, I'm invoking the juries to be removed, and then we do this for the entire defense direct?
No, Your Honor. What I would suggest is that if we get into this posture, and absolutely cross-examination may be sufficient, but if we get into the posture of needing additional, I would suggest that potentially proffering the questions, and then she and her counsel can advise the court if she intends to invoke her privilege at that time.
Mr. Lauro, last word, and then I will rule.
Yes, Your Honor, the statement by counsel is patently incorrect and false. This issue was raised by Ms. Kowals in the McMonaghan trial. She preserved the issue. She made the same arguments that these defense lawyers are making now. It was wholly rejected by Judge Wheeler and wholly rejected by the first DCA. And we respectfully request that Your Honor follow that ruling here. There is simply no question that the defense could ask that is relevant to this matter that Ms. Adelson, my client, would answer. She's invoking her Fifth Amendment.
This is not me. This is from.
All right, having reviewed the applicable authority on this issue and also reviewed the prior transcripts on this matter that were also ruled on by Judge Wheeler concerning this same subject, I am going to adopt a similar ruling. The defense cannot give the witness immunity as it relates to any matters in which she would testify under and could properly invoke the Fifth Amendment privilege. No witness can be called to the stand simply to invoke the Fifth Amendment, as there would be no basis for this witness to take the stand and give testimony on a relevant matter that also could not affect her ability to also endanger her own Fifth Amendment right. I am going to grant the relief that is requested. If we need to revisit this issue for any purpose where the defense believes there is a line of questioning that will not go to the Fifth Amendment privilege of the witness, we will at the appropriate time, but I do believe it is the proper ruling at this point to quash the subpoena. Mr. Lauro, I believe that concludes your motion for today. Again, when it's time for your client to testify, you may place your statement on the record.
Thank you, Your Honor. Good day, sir.
To you as well. That concludes the public portion of the hearings for this afternoon. We will take a brief break and then resume with the in-camera.
All right, and that was all that happened. That is all that happened. I must say this is a bit annoying because this is Donna Adelson. She's the defendant. If this gives, in my opinion, the state a bit of an unfair advantage because this immunity deal can be forced on Wendy. And the remedy for the defense is just a cross-examination, which seems to be limited in scope of the direct examination. That is, and if Wendy decides to plead the Fifth, then so be it. So I'm not happy with this ruling. I didn't know this ruling happened in the Catherine McMurd trial. Because even though I really don't like Donna Adelson, which might have been apparent to you all guys, she still has the right to a fair trial. I don't think this might not reach the unfair. Well, I do think it's unfair because now the state can elicit testimony from Wendy that points to Donna. And even if Donna has information that Catherine definitely didn't have, they can't do anything. I think that is fundamentally unfair. That the state is given, just because they have the power to give immunity, the defense cannot impeach. as it seems. They can't call, unless something else happens, they can't call Donna to the stand, or they can't call Wendy to the stand if other things happen in the trial that they know Wendy can rebut. Yeah, I genuinely think this is unfair. Now, we'll just wait and see. Tomorrow, jury selection begins, August 19th. I don't care one bit about jury selection. Won't cover that. I will do other things instead. Trial will probably start Wednesday or Thursday. That I will cover because I covered the Kathleen McMenemy trial and the Charlie Adelson trial, and I will cover this one for you all the way up until I travel to Utah. So it might be a slight, with my luck, it will be. If this trial goes to the jury while I am on an airplane crossing the Atlantic, I'm going to be so mad. But not much to do about that. Thank you for tuning in. You all have a good one. From me and Mr. Dingles. Hug your family. Unless your family's crap, then screw them and give your love to the people who deserve it. Okay, see ya. Bye-bye.